expected to emerge by popular vote, and as specified in Section 134 of the of the 1999 Constitution, it is in this respect that all votes cast at an election must be duly secured, collected, and counted. The Electoral Act is so clear and explicit on the issue of the votes cast and the results at the election. So for that purpose, I produced Section 25 of the Electoral Act, which stipulates the steps to be followed. So this provision makes it clear and straightforward that voting for all elections takes place at the polling units, and that is where the election is won or lost. The law requires that since the election, the present election, unlike others, is not done in one location but throughout the country, collection of votes commences at the registration area, so ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the national collection center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 and 60 of the Electoral Act deal with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is tried that where words used in a statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meanings. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imano and others versus Anekwe and others, Jegede and Anek, Guma and versus APC and others, Lado and another versus Masari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision or pretension as to any form of counting and collection of election results other than manual collection. In Oyetola and Anik Supra, the Supreme Court, per Agim JC, held on transmission of results, the essence and status of the collection system, and the Anik RF portal as follows. Court, as I had held herein, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit result during election to the ANIC database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their polling units, polling agents, where available to such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from subsection 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic Register of Election Results, which shall be a distinct database or repository of polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collection system and the ANEC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the positions of Regulation 38(1) and 2 that the collection system and result viewing portal are different from the National Electronic Register of Election Results. The collection system and result viewing portal are operational during the election as part of the process. The National Electronic Register of Election Results is a post-election record and is not part of the election process. With this step of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition. Thus, for reproduce paragraph 13 and 14. So the petitioners, by this pleading, are relying on the summary of final collation and declaration of results, which are in forms ECDA, in bracket, EC8E, as issued by the first respondent. The issues generated on this were not about the scores, but the alleged invalidity of the scores and the error of calculation of the scores. This pleading was not admitted by the first respondent. In reply, the first respondent joined issues with the petitioners in paragraphs 9, 10, 11 of their reply filed on 11 April 2023, which paragraphs are produced. It is settled law that issues for trial by the court are joined in the pleadings, and the parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. See the case of Uruwari and Osla and Nada versus Dixon. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW21, Mr. Samuel Oduntan. It was filed on 14th of June 2023. The statistician's report was tendered, admitted, and marked exhibits PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondents, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out, and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW21, the maker of the said reports, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a subpoena witness whose witness statement of oath was not front-loaded. He did not present himself as a credible witness. Hear him under his cross-examination by Mahmoud SN for the first respondent. He said, I have formal training in information technology, IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read INEC forms EC8S. I commenced my work sometimes in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. I could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I have seen page 4 of exhibit PAH1. That page refers to the methodology I use as referring to forms EC8S. I inspected the forms EC8S at the INEC headquarters. I do not know if those forms EC8S are before the court. I am aware that the form EC8S are stored in the various state headquarters. If what I stated in paragraph 2 at page 4 of exhibit PAH1 is wrong, my conclusion will be wrong. I have seen column 1 of volume 3, exhibit PAH4 at page 1, line 1. It refers to polling unit 009, ward 6 of Anambra State. When cross-examined by Chief Olani Pekon SM for the second respondent, the PW21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that No pictorial images of the electoral documents are referred to in my statement are attached to my statement. I'm aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I'm not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH 2. Furthermore, in response to the cross-examination of the Learned Senior Counsel for the third respondent, Fabian ESN, the PW21 said, "It is true that I have been following ANIC activities since 1999. There was a time that ANIC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANIC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. The same volume 3 of my report deals with ANIC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I'm aware that BVAS machine was used for accreditation. I'm the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It is in the instant case, it has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that Form EC8A series were altered and were not signed. It also talked of 15,002 polling units, where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several Forms EC8A series had a lot of alterations and that they were not signed by the presiding officers. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature from stamp and any alteration on the forms. Since PW21, who authored Exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submission of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153(1)(f) of the Constitution, and part of its functions as stated in paragraph 15, item F, part 1 of third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area council of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collation officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of section 64 provides for what the collection or returning officer will use to verify and collect the results, subsection 5 also provides for what the collection or returning officer will use to collect the results. Subsection 6 of the same section provides for what the collection or returning officer will use to determine the correctness of disputed result where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under section 47 sub 2 of this act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under section 60 subsection 4 of the act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in section 61, transfer in section 65, and transmitted directly in section 50 sub 2, 64 sub 4, 5, and 6 of the Electoral Act in stating how results of elections should be handled under those provisions. A look at the definition of those words in the Black Law Dictionary 6th edition show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as INEC Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38(1), Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and paragraph 93 of the regulations and guidelines. Paragraph 38, those provisions refers to have been reproduced in this judgment. So from the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in section 62(1) for the delivery by the presiding officer of the result, along with other election materials under the security and accompanied by candidates or their polling agents, were available to such person as may be prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collection system in addition to the physical transfer of the election results to the registration area for vote collection officer. As stated earlier, the technological device prescribed by INEC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 12.3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC88 to the annual result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area for ward collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the result viewing portal RF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANIC results viewing portal RF is not a collection system. Thus, the Supreme Court in Oyetola and ANIC has explained the difference between the collection system and RF, where Agim JSC held as follows. As their names depict, the collection system and the ANIC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANIC bylaw, also state that hard copies of election results shall be used for collection, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists that electronically transmitted results or results from the ANIC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that it's substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish that through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus ANIC, Audu and ANIC, Oke versus Mimiko, Kente and Ishapu, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is Section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the president as in Section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of